All right, I'm going to give one more explanation of the instructions, and then we're going to get started with Chiquetta and Raquel. Thank you everyone for being here. We are just about to get started. During the presentation, you're definitely welcome to ask any questions. We're going to answer as many questions as we have time for today. You can do that by pressing the Q&A button at the bottom of your Zoom window. And those questions will go in writing to me, and or comments, and I'm gonna read them to Chiquetta during the Q&A time, and we're gonna answer as many as we can. I'm just gonna ask them in order. So I'll try to get to as many questions as I can. And do fill out that poll, kind of let us know who's here so we can know how to direct the questions. Otherwise, I think we're ready. Oh, and there is a question already in the Q&A asking if we muted everyone's audio and disabled their cameras. We did. For public security reasons, we're required to at the city. But we still want to get your feedback, and that's why we're going to be taking questions and comments in the Q&A box. And we're going to do it that way as opposed to doing a different kind of public comment. So please submit your questions there and fill out our poll. But otherwise, Raquel, you can stop sharing the screen. And if Raquel and Chiquetta would turn on your cameras, and we're ready to start whenever you are, Quetta. Let's see. We'll turn the start button on. And we're gonna unmute you, Quetta. All right, thank you, everybody. Let's get started.
Good evening, and thank you for joining us. My name is Chiquetta Elder, and I'm the Landlord Tenant Coordinator with the Office of Equity and Human Rights. Also joining me will be Raquel Sager, who's also with the Office of Equity and Human Rights as the Rental Housing Specialist. And last but certainly not least, we have Kenny Copel, the man behind the voice. The purpose of this meeting is to provide you with information on the recent changes to the City of Tacoma's Rental Housing Code, which went into effect on February 1st, 2019, as a part of the city's Affordable Housing Action Strategy Plan. As of May 10th, 2021, Washington State went from a no-cause state to a just cause state as it relates to termination of tenancy. Therefore, in order to terminate tenancy in a rental housing in the state of Washington, the landlord must have a legitimate business reason as to why they're terminating the tenancy. Our rental housing code was written under the previous no-cause law. Therefore, our rental housing code was out of compliance with the state law and did not allow us to provide enforcement on violations, which required a tenant to use only civil remedies. Good thing is that since the rental housing code went into effect February 2019, mostly all of the state laws have changed to mirror the rental housing code. Therefore, whether you live or operate rental housing inside the city limits of Tacoma or elsewhere in the state, the same laws have to be followed in most instances. The only big difference is the rental housing code has an enforcement mechanism where the state law only has civil remedies for violation. This evening, I will give you a brief overview of the current rental housing code and then details on the recent changes. At the end, we will go over proposed changes to the rental housing code in the future. I'm sure you're wondering why we didn't do all the changes at one time. The reason is because we believe that housing is a partnership between the City of Tacoma, housing providers, and tenants. Therefore, we must do community engagement to get input and work with our stakeholders group that represent the changes we are considering to the code. With that said, let us get started on tonight's session. I will give you a brief overview of the code as it is currently written, and then we will have a question and answer session later. So the original code consists of, so under RCW 59, I'm sorry, excuse me, I'm so used to saying the landlord tenant laws. Under Tacoma Municipal Code 1.95, 030, landlords have to do distribution of information at 3 stages during the tenancy. At the application phase, at the when they offer a rental agreement, they have to give that rent in Tacoma packet. And then they have to give the notice of resources whenever they're serving any kind of notice that can lead to eviction. And then there's a section in the code where a landlord has to comply with and consider all reasonable accommodation requests as outlined in the the discrimination code 1.29. And then there's section of our rental housing code 1.9540 just outlines the requirements for the installment plans and deposits that are collected under both the state law and the City of Tacoma's rental housing code. So as you can see, it gives you all the information there on when the state law changed and what the requirements are. So I won't go into too much detail on that. And then the next part of our code is the requirement for rent increase, which is 1.95.060, which is also a part of the state law effective July 28th, 2019. And then the notice to terminate tenancy under 1.95070 section B, when the landlord wants to demolish, substantially rehab, or change the use, and that does not include selling the property for change of use, the 120-day written notice is required. And that's also in the state law. And then the next one is the tenant relocation, which is 1.95080. And that is in two sections of our code. It is under the demolish, substantially, and rehab. That's for low income tenants. It may trigger a relocation cost in the amount of $2,000, which is a 50-50 split between the landlord and the City of Tacoma. And then also in the state law, RCW 5918.085, if the property is dimmed by a government official, the tenant is entitled to $2,000 or 3 times the monthly rent in relocation costs, and the landlord is fully responsible for that. And that is not just for low income tenants. The next part of our code is the enforcement and compliance piece, and that's 1.95090. It includes retaliation as outlined in the state law, and then it also includes a tenant's right to organize. So those are what's covered under the code as it was currently written prior to October 1st, 2021, when we made recent changes to the rental housing code. So the next thing I'll go into is the recent changes. Under the state law, House Bill 1236, effective May 10th, 2021, and was codified into 5918.650, there are 17 just cause eviction reasons why a landlord can terminate someone's tenancy. And then there are 2 situations in which a landlord can still give a tenant a no cause notice. So in the City of Tacoma's just cause eviction, Tacoma Municipal Code 1.95070 subsection B, effective October 1st, 2021, there are 17 just cause reasons also. And then it allows for the 2 situations where there are no cause notices that are able to be served to a tenant. And then our code allows for enforcement where the state law doesn't. So I'll give you an overview of those changes, the situation. So this is the situation number 1, where a landlord could still serve a tenant a no cause notice. If the tenant is on a fixed term, 6 to 12 month lease, then rolls over into a periodic or month-to-month tenancy by the terms of the rental agreement, then no cause termination allowed with 60 or more days notice, but only at the end of the initial 6 to 12 months term. If the landlord does not terminate at the end of the term, then just cause applies therefore under RCW 5918.650, subsection 1B. So for an example, if the tenant signs a 12-month lease that rolls over into a month-to-month rental agreement, at the end of the lease, the landlord can give a 60-day notice, no cause, and that's fine. If the tenant signs a second 12-month lease that rolls over into a month-to-month, no cause is not okay, and the landlord has to have a reason to terminate tenancy under the just cause eviction. Example number 2, if the landlord if the tenant has a 9-month lease that rolls over into a month-to-month at the end of the 9 months, the landlord can terminate the tenancy, with the 60-day no cause. If the tenant becomes a month-to-month tenant for a few months and then the landlord wants to terminate their tenancy, they can't give a 60-day notice because it has to be done within that first 6 to 12 months. And then if the tenant signs a new 12-month lease at any type, the landlord still can't give a 60-day notice to terminate tenancy. No cause, sorry. Situation 2, if the tenancy is for a fixed term and does not roll over into a periodic or month-to-month tenancy afterwards, then no cause termination at the end of the term with 60-day or more notice is okay if the original fixed term lease was for 12 months or more, or the tenancy was 2 or more consecutive 6 months fixed terms, and the tenancy never became periodic or month-to-month at any point. RCW 5918.650, subsection 1C. So the first 12-month lease that does not roll over into a month-to-month tenancy ends, the landlord can give a 60-day no cause notice. The second one doesn't roll over, it ends, the landlord can give a 60-day no cause notice, and then that will be for the third one. The landlord and the tenant have the first lease is a 6-month that does not roll over into a month-to-month at the end of the 6 months. The landlord cannot give a 60-day no cause. The second 6 months lease that does not roll over into a month-to-month and ends at 6 months, the landlord can now give a 60-day no cause notice. And then the third one, if it doesn't roll over, the landlord can give a 60-day no cause. So basically, a tenant has to be able to reside at the property for 12 months consecutively, between 6 and 12 months consecutively, before the landlord can terminate the tenancy with no cause. So then the next section is we're going to go over what is considered legal reasons to terminate tenancy under the just cause eviction. So non-payment of rent, a landlord can serve a 14-day pay or vacate notice. Oh, there's a typo there, sorry. So rent can include monthly charges such as utility bills. And then they can serve the notice if the default payment under the deposit plan or the repayment plan under House Bill 5160. And then the next one is for breach of lease. The landlord can serve a 10-day comply or vacate notice, and that's for any non-monetary breaches of the lease. And then the tenant can remedy this situation. And then for waste, nuisance, or illegal activity, the landlord can serve a 3-day notice to quit. There's no cure period for the tenant and they must vacate. Nuisance generally is substantial and unreasonable interference with the ability of neighbors or the landlords to use and enjoy the premises. So the next one is landlord or immediate family to occupy unit, 90-day notice to vacate. So immediate family member includes registered domestic partner, parents, grandparents, in-laws, etc. And it's not applicable if the landlord has another apartment or house that is vacant and is substantially the same. And the landlord or the immediate family member must live in the unit as their principal resident for at least 60 continuous days during the 90 days immediately following the vacation of the tenant from the unit. Okay. Intent to sell. Okay, 90-day notice of intent to vacate, only if it's a single family home. The landlord must take steps to sell the house within 30 days after the tenant vacates, listing the house for sale at a reasonable price. There's a presumption that the landlord did not intend to really sell the house if the landlord did not list the property within 30 days after the tenant vacates, or takes the property off the market or rents it to someone else within the 90 days after the tenant vacates. Demolish, substantially rehabilitate, or change the use, 120-day notice to terminate tenancy. So demolish means destruction of premises. Substantially rehabilitate means repair or remodel requiring a permit that displaces the tenant. Changing use means conversion of the premises from a residential use to a non-residential use that requires a displacement of the tenant. And it may trigger relocation assistance for low-income tenants. Okay. So the next one is conversion to condominiums, 120-day notice. The landlord plans to make the reno a condo. And then the next one is premises are condemned. It's a 30-day notice to vacate or sooner if the local agency's order requires less time. So a government authority has certified that the premises is to be uninhabitable, and the landlord would be subject to penalties if the tenant continues to reside at the premises. And it may trigger relocation assistance if of all legal eligible tenants and not just low-income tenants. Share space with the owner, a 20-day notice to vacate. If the tenant rents space in landlord's dwelling and share kitchen and bathroom, so the landlord can serve a 20-day notice to terminate tenancy. Transitional housing, 30-day notice to vacate if a tenant finishes or no longer qualifies for the program. Failure to sign a new lease or rental agreement, 30-day notice to vacate. Tenant refuses to sign new lease or rental agreement. Lease provided 30 days before expiration of current rental agreement, and the terms of the new agreement must be reasonable. Next slide. So the next type of legal notice is application fraud, and the landlord can give a 30-day notice to vacate. Tenant provided intentional, knowing, and material misrepresentation or omissions on the rental application, and the landlord would have denied the application or requested more information. Then other economic or business reasons, the landlord can serve a 60-day notice to terminate, to vacate. The landlord has a legitimate business or economic reason to no longer rent the dwelling not covered under the other causes. Repeated lease violations, a 60-day notice to vacate. Tenant has received 4 or more written 10-day comply or vacate notices within the past 12 months. The landlord must specify the reason and be served with, and the notice must be served with or after the 4th or subsequent written notice to comply. Next slide. Sex offender, 60-day notice to vacate. If the tenant must register as a sex offender during the tenancy, if the tenant did not disclose that they were a registered sex offender on the application. Sexual harassment, 20-day notice to vacate. If the landlord believes the tenant has made unwarranted sexual advances or sexual harassment, the property owner, a manager, or another tenant in violation of the lease. If the landlord believes the tenant harassed this other person on the basis of race, gender, or other protected status. Hold over occupants not on the rental agreement, 30-day notice to vacate. If the tenant has been living in the rental for at least 6 months and the person on the lease moves out, then the remaining tenants can get a 30-day notice to submit a rental application, and the landlord must use the same screening criteria that they do with every other applicant. And as I stated earlier, we adopted the just cause evictions effective October 1st, which we pretty much just did all of the state ones, but we did do a couple of amendments and then added some changes to ours that we made enforceable. So one of the amendments was to the section where it says share space with the owner that requires a 20-day notice to vacate. That's still the same thing, 20-day notice to vacate if the owner shares a space with the tenant. However, the exception is when the landlord rents to 4 or more tenants in the same dwelling unit. So if it's a landlord and 3 tenants, that's fine. That's still considered the roommate situation as long as they share the kitchen and the bathroom. But when it goes to 4 or more tenants, we consider that multifamily property at that time. And you're not operating as a roommate situation, so you have to follow the other just cause evictions to terminate tenancy. And then some of the other changes we did in our enforcement section was there's enforcement around any rental agreement which has illegal lease provisions as outlined in RCW 5918.230 as it currently exists or hereinafter amended. And then also violation if the landlord requires a tenant to give more than a 20-day notice to vacate as outlined in RCW 5918.650. And the reason why for that last one is because we know with most people in this rental housing market, landlords aren't going to hold rental units for like 60 days. So if a landlord is trying to require a tenant to give like 60-day notice, that's not going to happen. And that creates a barrier for tenants finding housing. Okay, next slide. And then so here's our compliance and enforcement. So there's a $500 per penalty for the first violation and $1,000 per unit. A $500 penalty per unit for the first violation and $1,000 per unit for each subsequent violation in a 3-year period for the distribution of information, not following the requirements for deposits and installment payments, not following their reasonable accommodation, and not providing proper notice on rent increases. There's a $250 per day per unit for the first 10 days of noncompliance and $500 per day for day 11 and beyond for noncompliance to the notice to vacate, tenant relocation assistance, retaliation, illegal provisions in the rental agreement, and requiring more than 20 days notice to vacate. Okay, so the next section is some of the things that we are proposing as changes to the rental housing code in the future. And as I stated, yes.
I apologize for interrupting. Can I ask you some of the questions that are related to that first section of your presentation?
Sure, that's fine.
So Daryl asked, does a text message qualify as written notice?
For what?
I don't know. Raquel, can you?
Yeah. So no, in the state laws, if it's anything that could, it has to be a written notice, and then depending on what it is, it has to be served in accordance with RCW 5912.040. So if a landlord is trying to give a tenant notice that could lead to eviction, they can't just send a text message. The rent increases, it does say it has to be a written notice or whatever. So I wouldn't suggest that a text message even is valid for that. I wouldn't do that as a landlord just to be able to protect yourself.
The person did clarify and say a text as a notice to vacate.
No, so any notices to vacate has to be in writing, and it has to be served in accordance with the state law, which is RCW 5912.040, and then the City of Tacoma's rental housing code, which is the 1.95040 or 030, and that's where they have to give that resource packet, not the resource packet, the notice of resource with the tenant for the expiration of the tenancy or the notice of termination.
Well, I have 3 more, and then the rest I'll ask at the end.
Okay.
Okay, so this person, Jason, asks where a 60-day I'll start over. Where a 60-day no cause notice is allowed, is the notice given at the end of the original lease term? For example, would this give the tenant an additional 60 days of tenancy beyond their original term?
No, it has to be served 60 days before the lease ends.
Perfect. All right, next question from Daryl. So is it legal for a landlord to say they're selling and then end up renting to someone else after the tenant moves out?
Well, no, that was on the slide about intent to sell. The landlord has to put the house on the market for 30 days. And then if the landlord within the next 90 days takes it off the market and does not sell it, or they rent it to someone else, that's a violation. It's presumed that they never had the intention to sell it. They were just using that as a way to get around the one of the legal reasons under just cause eviction.
Thanks. I'm purposely asking questions, even if I know you answered already, just so the information doesn't get lost for people. So thank you. And last question before you go back in. This is from Nancy. Nancy asked, so if a homeowner has more than 4 rooms occupied by 4+ people, how do they go about evicting or trespassing the people?
They have to have one of the legal reasons under the law. So that it would have to be that they're non-payment of rent, out of compliance with their rental agreement, any of those 17 reasons that they had, you would have to use that and then follow the state unlawful detainer eviction process as you would with any other rental.
All right, and Nancy, if you have follow-up questions, feel free to put them in chat and we'll ask them later. Thanks, Shaquetta. We can go back.
Okay, so the next section is proposed changes to our rental housing code. As I was just explaining, when we did the rental housing code updates in the beginning, we needed to get our law in compliance with the state law. So we didn't take the time to look at all of the proposed changes that we've identified as issues with the rental housing market. Was a result of the survey that we've done with at the end of our first year with the rental housing code. So these are just some of the things that we've identified. And so before we make any changes to the rental housing code, we always go out and propose it to the community, get input, work with stakeholders and things like that. So these aren't just something that we're gonna do. It might be something that we've identified at the city, but it may come to find out that it really isn't a problem after we work with the community or hear the community. So these are just a couple of the proposed ones. They could change, more could be added as we go out and do our outreach and speak with the community. So shared housing standards. Some of the things around that is making sure that people who are operating shared housing follow the occupancy and the zoning requirements for the city of Tacoma. We want to assure that only authorized spaces are rented. We don't need people living in uninhabitable spaces. And then eviction standards when master leases are involved. So one of the reasons why we kind of want to put some standards around shared housing too is because we know that it is very needed in the state around the country because of the way the housing market is. However, we don't want to put people in situations that are going to endanger their lives, but then also we have to think about the neighborhoods that are that these houses sit in, because there's impacts on the neighborhoods too when you have shared housing in spaces that are zoned single family and things like that. So that's why we're looking at some of that. So late fee standards. One thing I want to say is that we're not looking to put any restrictions on if the landlord can charge late fees, how much they can charge in late fees, because we actually can't do that. The state law prohibits us from doing that. But we kind of want to put some standards around how a landlord addresses late fees during the tenancies. Because what we found is some landlords charge late fees, and we know that there are legitimate business reasons as to why, most of them, but there are some who just do it as a tenant pay, and they never address it. And then at the end of the tenancy, they will hit the tenant with like a big bill, and then the tenant wasn't aware that they owe all that, and that can cause a barrier with a tenant finding housing in the future. So we want to put some standards around that, and that could include prohibiting a landlord who does not address the late fees during the tenancy from collecting or reporting to prospective landlords at the end of the tenancy. And then the next proposed change is notice of proposed sale of low-income housing. Require landlords to notify tenants in low-income housings on their intent to sell. Because what we all know is that when a person is low income or on a very low limited income, it's a little bit harder for them to find housing than it would be for somebody who has a different type of income. So if they know that the owner is selling the house and that there is a possibility that they may have to vacate once the property sells or before the property sells, then it helps them better prepare. And they won't have a housing barrier that could create something that makes them go homeless in the future. And then restrictions on Fallon evictions if the housing provider does not have a valid City of Tacoma rental business license. A business license is required in the City of Tacoma, whether you're renting a room, a closet, a whole apartment complex, anything. So any type of housing transactions inside the city limits of Tacoma requires a business license. And the reason why this is important is because we use our business license as an outreach mechanisms to housing providers to keep you up to date on our code changes, our proposed code changes, outreach events, things like that. So if you don't have a valid business license, you're probably not operating under what the Tacoma City Housing, City of Tacoma's rental housing code requires. Therefore, you can find yourself getting fees and penalties and things like that. And also it creates issues with your tenants that could possibly lead to housing barriers and evictions and things like that. So yes, those are the proposed changes. And so the next step around the proposed changes is the community outreach events. I mean, we'll hold community outreach, we'll hold events in all 4 sectors and then the council districts and conduct focus groups and then conduct surveys. And then we'll work with our stakeholders. We've handpicked stakeholders that represent each of the types of proposed changes that we want to do. So we have the landlord associations, the tenant associations, the real estate associations. We have landlord and tenant legal representation, shared housing partners there, like the Tacoma Pierce County Coalition to End Homelessness. We have representation from there. Fair Housing Center of Washington, the Affordable Housing Action Strategy. I didn't list all of them. Excuse me, the Affordable Housing Low Income Housing Consortium, and then all the city departments that will be affected by any of the code changes. And then the next step is we present to council and they would give us direction and pass the code changes if they felt like it was something that they wanted to do. So those are the next steps around the proposed changes. And then the next thing is contact information. If you need information or assistance with the rental housing code, you can go to the City of Tacoma's website, www.cityoftacoma.org/rental housing code. You can call 311 or 253-591-5000, or you can do it online at Tacoma First 311. And then if you would like for more information or provide input on the proposed changes, you can go to the Rental Housing Code webpage, or you can email to the Tacoma Rental Housing Code at cityoftacoma.org. And then that concludes my section, and I will turn it over to Kenny for the Q&A.
Thanks, Shaquetta. So everybody, we're going to start taking all of your questions. So you can post questions by pressing the Q&A button at the bottom of your Zoom window and submit them in writing. I'm going to read as many as we can. There's just a few so far, so we might even end early if we don't have any more questions. Shaquetta, the first question is, we have 2 people wondering if the slides are available. Is this presentation available?
Yes, the presentation will be posted on the City of Tacoma's Rental Housing Code webpage.
Raquel, could you post that in the chat for everyone if you're able to grab it? So that's 2 of our questions. All right, first question is from Ursula. Shaquetta, is there a way to locate whether or not your landlord has a rental property license?
You can, we check that. That's one of the things that we check when we if a tenant calls us. or if a landlord contacts us. That's one of the things that we do check with the City of Tacoma, but you can contact the Tax and License Department, and they may be able to provide you with the information. I'm not sure if you have to do a public disclosure request for that information, because if you're not the property owner, but there is a way you can contact Tax and License to find out. But we do check that information when people contact our office for assistance, whether they're a landlord or a tenant.
Cool. Raquel, would you mind posting that link in the actual chat so everyone can see it? Just to the rental housing page. It was on the PowerPoints, but some people might not have grabbed it in time. All right, so this next question is a little bit larger than what was in your presentation, but I'd still love to hear your thoughts on it, Chiquetta. David asks, does Tacoma allow Tacoma Housing Authority and or other housing providers a right of first refusal for naturally occurring affordable housing? Sorry, the sentence has a missing word in it. I'll try to read it again. Does Tacoma allow THA and or other housing providers a right of first refusal for naturally occurring affordable housing to be sold? David, I might need you to re-ask that question if Chiquetta didn't understand it.
So no, right of first refusal is not currently in our code.
Okay. So reach out to Chiquetta if you want to learn more about that or advocate for that. All right, next question. This is a follow-up to that one before. I'm going to read the one before again for you, Chiquetta. Let me find it. Okay, so it's the one about the, if a homeowner has more than 4 rooms occupied by 4 people, how do they go about evicting or trespassing people? Related specifically to the 20-day notice. You said there was an exception for when there's 4+ tenants. Can you please clarify the differences for someone with 4+ tenants? Can they issue a 20-day notice? If not, what can they do?
No, that's what the 20-day notice only applies to roommate situations. When you are renting more than 4 notices, you have to follow the same law that a landlord that rents to 20 people that has a 20 unit complex does, because you're no longer doing, it's not considered a roommate, it's considered multifamily. So you would have to have a valid reason under one of the 17 reasons under just cause eviction to terminate the tenant's tenancy.
Thank you very much. Next question from Daryl. Some assistance. Oh, sorry, I'm having a hard time understanding the question. This person wants to ask for a W-9 from their landlord. Can the landlord refuse to give a W-9?
Yes.
Okay. All right. So a couple questions asking to view all. Where can I view or download the Tacoma rental documents, the one a housing owner must share at application, at lease signing, and when a notice is served that may lead to eviction?
They're on the City of Tacoma's Rental Housing Code webpage. The ones that have, there's a copy of the Rental Housing Code in both the sections for the landlords and the tenants. The documents that the landlords have to share are in the landlord resource section, and we're in the process of updating all of those. So, but they're on the Rental Housing Code website.
Great. And
That's in the chat as well.
Thank you. Yeah, if you press the chat button at the bottom of your screen, Raquel just posted that for everybody. Thank you, Raquel. And we only have one more question. So if people have any questions about anything that was in the presentation, please submit them now. And if you have any, if you saw those proposed changes and you wanted to contribute your thoughts or comments, you're welcome to do that. I'll read them all to Chiquetta. All right, so next question is from Jason. One of the 4 cause reasons was for, quote, legitimate business reasons. Can you provide a definition or examples of what these might be?
Is he talking about the business or economic reason?
I believe so.
He would have to talk to his attorney because the state law doesn't give a clear definition of what that is. So if it doesn't fit into one of the other 17 reasons, they would have to talk to their attorney to make sure that the reason why they can't rent the rental property again doesn't fit into one of the 17 reasons, and they have to give a legitimate business or economic reason. And the state law unfortunately doesn't give a very clear definition of that. So I always suggest the landlord speak with their attorney about that. And if the tenant gets that type of notice from the landlord, they seek legal advice also. And I suggest that a landlord seeks advice from an attorney before they serve any of these types of notices to make sure that they're doing it correctly and then that they're using the correct cause so that they don't get all the way before a judge and it gets kicked back. And if a tenant gets a notice and they're not clear on whether the notice is legal or if they don't agree with it, that they need to seek legal advice also.
Great. We only have one more question, so I'm going to give people one last shot to put them in the Q&A button at the bottom of your Zoom window. While I'm asking this question, Raquel, will you post your and Chiquetta's email addresses in the chat? So if you do have further questions, you can definitely reach out.
No, they need to, sorry, Kenny, they need to go through the either 311 or if they can do the information through the Tacoma Rental Housing Code.
Okay, great. Then will you provide that information? Thank you. All right, so next question from Sunny. What if a landlord never provided a signed copy of a month-to-month lease?
So if the landlord hasn't provided a signed copy of the month-to-month rental agreement, the tenant has to request it in writing from the landlord. And then during the tenancy, even if they did provide it and you need another copy, the law says that the tenant can receive one free copy during the tenancy. However, you have to put your request in writing. You can't verbally request it from the landlord. You have to request it in writing.
All right, thank you very much. That looks like our last question. So if Chiquetta, you could just say goodbye and, oh, one more. So someone's asking if you could post the last page of the presentation that put the contact info. So we'll just leave that up. Will you share that screen and we'll just leave that as we're leaving the meeting, Raquel, and we'll just leave it up for like 2 or 3 minutes. And then Chiquetta, if you could just give us some closing thoughts and say goodbye. Thanks, everybody.
Okay, so thank you all for joining us this evening. And we are here to answer any questions, take any input that you may have on the proposed changes. Just know that we at the City of Tacoma are not doing anything that's outside what the state law is requiring because their code pretty much mirrors our code. We just have the enforcement mechanism because what we found is that some tenants don't have the bandwidth or the time to take a landlord to court civilly, and it's just easier if we work with the landlord to get them to come into compliance. My thing that I said when we first created the rental housing code, and all of our stakeholders that work with us can tell you that I've always said this, we at the City of Tacoma, if we don't ever have to enforce on anybody, that would be perfect because that meant that everybody is working together, landlords, tenants, and the City of Tacoma, so that we can have safe and stable housing inside the Tacoma city limits, which is what we really want. So again, the PowerPoint, or excuse me, the webinar PowerPoint will be posted on the Rental Housing Code webpage after I make a correction that I noticed that I needed to make. And we'll also post on there about our information sessions that we have upcoming. And then if you are renting property in Tacoma and you do not have a business license, I suggest that you get one as soon as possible so that you know when we have our outreach events, you know what changes have been made to the code so that you're in compliance and it saves you from getting penalties and things like that. So again, we are here to help you with any information that and referrals as it relates to the state landlord tenant law and the rental housing code. But we really want to hear your feedback on those proposed changes and have you guys come out to all of our outreach events and everything. So be on the lookout for those. And thank you again for joining us.
Thanks, everybody. We'll keep the room open for just 2 or 3 more minutes if you need to write down any of this contact information. But thank you so much. And Chiquetta and Raquel, you're free too if you want to go. I can keep the room open for just a couple more minutes.
I'll stay here just in case somebody has a question.
Sure, yeah. And if anyone else posts any other questions, we don't need to rush out. Just got a thank you from Brittany. If you want to press the raise hand button, I might even, I can unmute you if you want to ask a quick question. Otherwise, we'll just wait a little bit longer for people to write things down. Oh, we got something in the Q&A. Oh, just another thank you. Thank you back. And give you about 1 more minute to write down that contact information or press the raise hand button if you want to be unmuted and verbally ask a question of Chiquetta. Thanks, Chiquetta. We got done 10 minutes early.
Yeah, because you had me scared. You told me I had to get all that done in 10 minutes, so I felt like I was speeding through it, Kenny.
All right, thank you, everybody. I think we are going to head out. Thank you so much. Have a great evening, everybody.